You'll recall that the Mental Capacity Act promotes autonomy through statutory principles that require health and social work professionals and others to allow people to make their own decisions. It also provides a framework for assessing when a person lacks the mental capacity to make a decision and sets out a process to be followed when deciding how to proceed in a person's best interests. The decisions covered by the Act are wide-ranging and include everything from what to wear to where to go to more complex decisions such as where to live or where to have medical treatment. The scope of the Mental Capacity Act includes decisions regarding welfare, residence and medical treatment for both physical and mental disorders. There are certain decisions that are excluded from the Act's best interests process. These can never be made on behalf of a person who lacks capacity. The decisions can never be made nor actions ever taken even by family members, carers, professionals, attorneys or the Court of Protection. The person has to have capacity to make these decisions themselves. They include such matters as consent to marriage or civil partnership, consent to have sexual relations, consent to a child being placed for adoption or the making of an adoption order, discharging parental responsibility for a child in matters not relating to the child's property, and giving consent under the Human Fertilisation and Embryology Act of 1990. Other excluded decisions include mental health matters under Section 28 of the Act, voting rights under Section 29, and unlawful killing or assisted suicide under Section 62. The Mental Capacity Act applies to persons over the age of 16, so it applies to adults and young persons. Mental capacity is the threshold for the best interest provisions of the Act to apply. The Mental Capacity Act applies to young persons who lack capacity with three key exceptions. Only adults can make a lasting power of attorney. Only adults can make an advance decision to refuse medical treatment. And the Court of Protection can only make a statutory will for a person who is 18 or over. If a young person lacks capacity because of an impairment of a disturbance in the functioning of the mind or brain, then the Mental Capacity Act will apply in the same way as it does to adults. If they are unable to make decisions for some other reason, for example because they're overwhelmed by the implications of the decision, the Act will not apply to them, and the legality of any treatment should be assessed under common law principles known as Gillick competence. If a young person has capacity to agree to treatment, their decision to consent must be respected. This gives rise to dilemmas if a young person has mental capacity and refuses consent, especially if a person with parental responsibility wishes to give consent on the young person's behalf. It would be the family division of the High Court that would hear cases where there was a disagreement. The Court of Protection has no power to settle a dispute about a young person who is said to have the mental capacity to make that decision. The Mental Capacity Act promotes autonomy through its statutory principles. Autonomy or self-determination is given its legal expression in the law of consent. So when a person gives a real consent to care, services or treatment, it provides you with a defence for liability in the tort or civil wrong of trespass to the person, which can take the form of an assault or battery. The importance of self-determination through consent in healthcare was clarified over a century ago when the courts declared that every human being of adult years and sound mind has a right to determine what shall be done with their own body. That principle is applied much more widely today and includes decisions about welfare and social care. An analysis of the Declaration shows that the law can be described as rules of human conduct. Adult years suggest the process is different for children, and soundness of mind is now referred to as mental capacity. We are human at birth, we're adults by age. Neither of these can be changed. The one variable there is the notion of soundness of mind or mental capacity. If a person is shown to have mental capacity, then they can make their own decisions or determinations, and the professionals involved must respect that decision, even if they disagree with the person's decision making. Lord Gough summed this up well when he said that if an adult patient of sound mind refuses, however unreasonably, to consent to treatment or care, those responsible for the care must give effect to his wishes, even if they don't consider it to be in his best interests to do so. We can see then that mental capacity is an element of lawful consent, real consent. For consent or a refusal to be legally valid, it must be made by a person with capacity. It must be real, that is, full and reasonably informed, and it must be voluntary. Capacity to consent isn't based on a person's status or age, but rather a question of fact in every case that requires the person understands what's involved in the decision to be taken. Capacity to consent is a question of the person's ability to understand that which the law requires them to understand. The law looks to the person's innate facility or aptitude to understand what's involved in giving consent. Is it relevant whether a patient actually understands what's involved? Well, it is necessary if the patient's consent is to be real and so valid. An uncomprehending consent is no consent at all. The law imposes an obligation to disclose the information relevant to a decision in a reasonably comprehensible way, or the consent will be invalid. The person's actual understanding is a useful yardstick by which to assess their mental capacity, their ability to make a decision. The case of Ray T also considered mental capacity in terms of decision-making ability, but the case also held that because mental capacity was essential to self-determination, it was the key to a person's autonomy. The right to decide one's own fate presupposes a capacity or an ability to do so. This ability to make decisions is not based on a person's intelligence or education, but rather their understanding, retention, and use of information. You'll recall that the case of C concerned a man with a profound mental disorder who was refusing consent to an amputation whilst he was detained under the Mental Capacity Act. The case established a test for mental capacity that has been largely codified in the Mental Capacity Act of 2005. The judge in the case, Justice Thorpe, held that to have capacity, the person must first comprehend and retain treatment information, secondly, believe that information, and thirdly, weigh the information in the balance to arrive at a choice. In reaching this view of mental capacity, Justice Thorpe rejected the consultant psychiatrist's paternalistic approach that because the man had a mental disorder and was detained under the Act, it was for them to decide on his treatment. The judge also rejected the professional approach to incapacity that suggested treatment should be allowed to proceed if two doctors signed that the man was of unsound mind. Interestingly, he also rejected the minimal competence test of capacity that only required the person to understand in broad terms the nature and effect of the proposed treatment. In his ruling, Justice Thorpe held that a person must be able to understand more than the broad nature and purpose of the procedure. He must also be able to understand the likely or possible effects or consequences of undergoing or not proceeding with the procedure in question. The case of MB concerned the mental capacity of a woman with a needle phobia who was refusing a caesarean section. And the judge in that case held that the proper way to approach an issue of mental capacity was to begin with a presumption, to start with the presumption that a person has capacity to make a decision, and that is for the professionals concerned to lead evidence that rebuts that presumption. This is a principle that applies in the Mental Capacity Act today. The issue in MB, said the Court of Appeal, was not whether the person had capacity to make a decision, but whether they lacked capacity to make the decision. Could the presumption of capacity be displaced? The presumption of mental capacity is now enshrined in the statutory principles of the Mental Capacity Act. you can see that the first principle requires that a person must be assumed to have capacity unless it can be established that they lack capacity. In a further effort to promote autonomy, the second statutory principle requires that a person is not to be treated as unable to make a decision unless all practical steps to help them to do so have been taken without success. The third principle ensures that a person is not considered to lack capacity because, in the view of the professionals involved, the decision is unwise or wrong. The term mental capacity is used by the Act to show that for the purpose of the Act, a person lacks capacity in relation to a matter if at the material time they're unable to make a decision because of an impairment of or disturbance in the functioning of the mind or brain. That is, the reason the person can't make a decision must be because of an impairment or disturbance to the functioning of the mind or brain. This approach has been described as the functional test of capacity. It requires you as an assessor to consider whether there's an impairment or disturbance to the mind or brain, and if there is it preventing the person from making a particular decision? When you assess mental capacity, any question whether a person lacks capacity within the meaning of the Act is decided on the balance of probabilities. On balance, are you satisfied that the person is unable to make a decision because of an impairment or disturbance to the functioning of their mind or brain? The Mental Capacity Act is accompanied by a statutory code of practice. Assessing mental capacity requires a methodical application of the provisions of the Mental Capacity Act and the Code of Practice. It is your duty to have regard to the Code of Practice if you're acting in relation to a person in a professional capacity or for remuneration. The courts, including the Supreme Court, stress the importance of consulting and acting in accordance with the Code when assessing a person's mental capacity.